Hey folks, this is Mansoor Sohail. I'm an accountant operating out of Toronto, Ontario, and my specialization is tax for Canada and USA. My today's presentation is for educational purposes only. It does not constitute any legal advice or opinion. Please do not use any of its contents without seeking a professional advice. I will be talking about sole proprietorships and partnerships today. So there are so many different ways people can do business, but basic main three different ways are sole proprietorship, partnership, and corporation. Let's discuss sole proprietorship. This option is available to businesses owned by one person. A sole proprietor can run a business under his or her name. If a name is registered with the government, one can operate business in such name. Sole proprietors may or may not have employees. Expenses incurred in operation of business are deductible. Some examples of expenses are stationery, telephone, rent, etc. If business is operated from home, sole proprietors may be eligible to deduct portion of mortgage interest, property tax, and utility bills depending upon percentage of home used for business. Sole proprietors should keep a separate bank account for their business. If someone wants to run a business in his own name, there are no requirements to register a business name. If someone wants to run a business under a different name, Section 2 of the Business Act requires that the name should be registered. Section 4 of the Business Act governs registration of names. Section 4-1 states that for a prescribed fee, a name may be registered for a period of 5 years before it must be renewed. Section 5-1 and 5-2 state that renewal of a business name may take place with the payment of prescribed fee at any time before its expiry and with the payment of an additional fee up to 60 days after its expiry. It's always recommended to search a name registration database, nuance, to confirm that the name is not already registered by someone else. The penalty for appropriating an existing name can be severe. Under Section 6 of the Business Act, a person registering a similar name that has already been registered before may be sued and end up paying heavy damages. Business name can be registered by completing Form 1 under the Business Names Act that is submitted to Ministry of Consumer and Commercial Relations. Here is a link to Form 1. Once a name is registered, you can carry on business under that name. Sole proprietors are liable for the debts and obligations of the business. Section 2-6 of the Business Act requires the sole proprietors to set out both the registered names and the person's name in all contracts, invoices, negotiable instruments, and orders involving goods and services. Sole proprietorships are very simple and easy to set up and operate. So let's get to partnerships. There is a Partnership Act RSO 1990 in force for partnerships. Partnership is defined as it is a relation between persons who carry a business to make profit. A partner in a partnership can be a human or a corporation. There are three main types of partnerships: general partnership, limited partnership, and limited liability partnership. Let's talk about general partnerships first. General partnership. It is the most common form of partnership. All the partners are equally responsible for the actions and liabilities of a firm. Each partner is an agent of the firm and the other partners and has the legal authority to bind the firm and other partners. Signing a legal instrument by any partner will bind the firm and all partners. If a partner borrows on behalf of the firm, it binds him and all the partners for repayment of the debt. The firm may agree to limit the powers of a partner. A deceased partner's estate is equally subject to liabilities of the firm like other partners. If a partner is an independent trustee for a third party and misapplies the trust funds, the other partners are not liable to this. The estate of a deceased partner is not liable for obligation of partnership that arise after death. Any written statement or representation made by a partner about the firm can be used as evidence against the firm. Any legal notice issued to a partner is considered to be a legal notice issued to firm. According to Section 20 of the Partnership Act, the rights and obligations of a partner may be varied by a partnership agreement. Any property bought by a partnership belongs to partnership. No partner can be expelled from the partnership unless there is a written agreement in place. If a partner does not want to be a partner anymore, dissolution is the only solution. If a partnership is created for a fixed term but remains active after the end of the term, the partnership continues to operate. Financial records of a partnership should be available to all partners. If a partner gets benefits privately, he must compensate other partners equally. No partner should ever operate a business that is in conflict of interest with the partnership. All partners share profits and losses of partnership equally. Partnership is liable to reimburse out-of-pocket expenses incurred by any partner. Every partner is equally responsible to manage the business of a partnership. No partner can be an employee of the partnership. Any new partner should be admitted to partnership with consent of all partners. Any disagreement can be settled with vote. A simple majority vote will decide the matter. Partnership agreements. Following are some of the issues that can be addressed in a partnership agreement, like name of the firm, decision of financial institution, signing authority, appointing an accountant or an auditor, borrowing arrangements and policies, initial contribution of each partner, purpose of partnership and limitations, if any, limitations on authority of a partner, allocation of tax, hiring and firing of employees, division of profits and losses among the partners, procedures regarding holidays, sick leaves, etc., liability insurance for partnership, procedures for adding new partners or removal of a partner, procedures in the event of death, bankruptcy, or mental incompetence of a partner, procedures for dissolving a partnership. Let's talk about name registration. Section 2 of the Business Names Act requires a registration of a business name of all general partnerships. Dissolution of partnership. According to Section 32 of a partnership will dissolve automatically at the end of its fixed term. If there is no fixed term, any partner may dissolve partnership by giving a notice to other partner. Okay, a partnership will dissolve automatically if its activities become illegal. A partnership can dissolve through court if the court is satisfied that a partner is incompetent, a partner is not able to perform partnership responsibilities, a partner has damaged the partnership ability to carry on business, a partner has breached partnership agreement. On dissolution, partnership property is first used to discharge the debts of partnership. Any surplus property is then used to pay each partner what he or she is entitled to under partnership agreement. A partnership agreement can specify the reasons and procedures for dissolving a partnership, but it cannot amend the division of assets rules. Advantages and disadvantages of general partnership. General partnerships are very simple to form and carry business. Setup cost is very little. Partners are free to arrange their activities. Liability is a big issue because partners are exposed to it. Each partner has the authority of an agent to represent and bind the partnership. Business assets and personal assets of partners, like house, car, bank accounts, and RRSP accounts, are vulnerable to third parties. Addition, withdrawal, ejection of partners, or dissolution of partnership can be difficult to resolve. Okay, limited partnership. Let's talk about limited partnerships. Limited partnership is governed by Limited Partnership Act RSO 1990 C.L16. Partners can contribute to an unincorporated business venture without assuming liability of partnership. A limited partnership will have one or more general partner and one or more limited partners. A general partner in a limited partnership is liable for all the debts and liabilities of the partnership. Limited partners are only liable up to their contribution to partnership. Limited partners cannot have their names included in the firm name and also cannot take part in the control and management of the business. If a limited partner takes part in the control of the firm, he or she is liable to all third parties, just like a general partner. A limited partner has the same right as a general partner to inspect the firm's records. A limited partner can have business dealings with the firm, like making loans to the firm and entering into contracts with it. Limited partners can have return of their capital contribution if the firm dissolves, a time is specified in the partnership agreement, on a notice of 6 months, or any time with consent of all partners. Limited partners can force the partnership to dissolve if their request for return of their contribution is improperly denied or if the firm is not able to meet its liabilities. A person or a corporation can both be general or limited partners in a limited partnership. All limited partnerships are required to file a declaration with the government. Registering this declaration with Ministry of Consumers and Commercial Relations will create limited partnership. Failing to register will result in the partnership losing all protection of the Limited Partnership Act. Registration of limited partnership lasts 5 years and must be renewed upon expiry. Failure to renew can cost late renewal fee. If name or any information changes, a new declaration must be registered. According to Section 4 of the Act, general partners should maintain a record of all limited partners and their contributions. This record must be available for public inspection. Dissolution of a limited partnership. A limited partnership will dissolve automatically in the event of retirement, death, or mental incompetence of a general partner, or if a corporation is a partner and it dissolves. A declaration of dissolution must be filed with Ministry of Consumer and Commercial Relations. Upon dissolution, assets of the partnership should be used to pay creditors. Remaining assets, if any, must be distributed as below. First, to limited partners, the share of their profit if not paid yet. Then, to limited partners, return of their contribution. Followed by to general partners, money due to them. To general partners for profit. To general partners for capital investment. Okay, let's talk about advantages and disadvantages. Limited partnership allows limited partners to invest in the firm and share its profits. Limited partners cannot bind the firm and general partners. Limited partnership is complex and expensive to create. Extra provincial limited partnership. Section 25 of the Act allows limited partnership created in other provinces or countries to carry on business in Ontario, provided they file declaration with the Ministry of Consumer and Commercial Relations. Section 25-4 requires the extra-provincial limited partnership to create a power of attorney, appointing an Ontario resident as its attorney. The name and address of this attorney must be listed in the declaration, and attorney must keep a copy of the power of attorney at the listed address. Limited liability partnership. It's available to only certain people. This type of partnership reduces the partner's potential liability. In a limited liability partnership, a partner is not liable for debts, obligations, and liabilities of the partnership. This type of partnership protects partners from liability for the negligence of other partners. Section 44.1-1 of the Act requires a written agreement for formation of a limited liability partnership. An existing partnership can continue as a limited liability if a new agreement is made that is according to Section 44.1-1. A limited liability partnership is similar to general partnership except that partners in limited liability are not liable for liabilities, which is a very big advantage. The cost of setting up limited liability partnership is slightly higher than that of setting up a general partnership. Folks, once again, this presentation is for educational purposes only. It does not constitute any legal advice or opinion of any kind. Please do not use any of its contents without seeking a professional advice. I have prepared this lecture from the Fundamentals of Corporate Law and Procedures written by Mark Walma and Patricia McCann Smith, published by Edmund Montgomery Publications Limited, Toronto, Canada. Thank you for listening.